was in a combi with other people. They went to a place called Lisedi,
Yeah.
had drinks there, and at a later stage, they were joined by accused number 5. They pick him up at George Koch Hostel, where they all went together
Okay, fine, yeah, I hear you.
to Main and Corner, Main and Nugget, where they were sharing a flat. And accused number 4 was then dropped off at Corner Jules and St. Clair in
The time of the being
in
dropped
Melbourne.
there is what? Is it after 8 or 9 or what? They don't mention.
Well, they don't mention that.
And when the gentleman makes a pronouncement about Senzo Meyiwa, it's no more.
Yes.
They were not there, obviously, according
Yes.
to their version.
Yeah, indeed, my lord.
Okay, fine.
Right, then back to here it's on page 26, paragraph 18. In the case of
Mr.
Yeah. In the case of Ditako, and Ditako is spelled Litako versus the State 2014, Volume 3, All South African Law Reports, 138, decision of the SCA. The SCA reconsidered the ruling in Ndlovu and found it lacking insofar as hearsay evidence is concerned.
Yes, yes, yes.
In Ditako, accused 3 and 4 during the trial disavowed the statement containing admissions they had made at the time of their arrest and rejecting the approach of the trial court which allowed the statement in terms of section 3(1)(b) of the Law of Evidence Amendment Act 45 of 1988, or the Hearsay Act. The SCA indicated that the admissibility of all hearsay evidence not affirmed during the trial under oath had to be considered in terms of the interest of justice test as provided for in section 3(1)(c), paragraph 3(4). Court will recall the 3(1)(b) is the provisional admission of hearsay evidence.
Yes.
So the trial court had used the wrong subsection. The SCA found that considering the reasons why the common law excluded the use of extracurricular admissions by one accused against another, it would be in the interest of justice not to utilize the Law of Evidence Amendment Act to allow such evidence as hearsay evidence against a co-accused. So Ditako departed from Ndlovu.
Yes, yes.
The court concluded that fair trial demands require that despite Section 3 of the Law of Evidence Amendment Act, the extrajudicial extracurricular admission of one accused does not constitute evidence against a co-accused and is therefore inadmissible against such co-accused. Paragraph 19. In S versus Mhlongo, S versus Nkosi, 2015, Volume 2, SACR 323 at 340, the Constitutional Court held that the common law position before Ndlovu decision, namely that extracurricular statements against co-accused are inadmissible, must be restored.
Yes.
So in other words, Ndlovu was overruled.
Yes.
Admitting extracurricular admissions against the co-accused offense against the right to equality before the law. However, my lord, paragraph 20, of importance is that the court in Mhlongo held that the distinction between confessions and admissions is determined by the extent to which a statement implicates its maker. Accordingly, there's no rational reason why, when used against another person, there should be a difference in the admissibility of the two types of statements. In the Ditako case, the SCA held that, and we quote, from the perspective of the one accused who may be implicated in the statement of another, one strains to discern a sound jurisprudential basis for the distinction. So in other words, both Nhlongo and Itako are saying there's no need to distinguish between confessions and admissions. And the importance thereof lies, my lord, in the next paragraph. The importance of not distinguishing between confession and admission when used against another person means that executive statements are admissible evidence against a co-accused if they are made in the furtherance of a common purpose. And we refer to the work of Hoffman and Zeffert, the South African Law of Evidence, 4th edition, at page 19. The authors explain what executive statements are. And they explain executive statements as statements made in the furtherance of a common purpose and are admissible evidence against co-accused. In order to be admissible, the statement needs to form part of the acts done in the commission of a crime. The executive statements of A, who acts together with B and C in furthering a criminal enterprise, are, if they are performed in the furtherance of a common purpose, viewed as being no less than the statements of B and C. They may therefore be adduced against B and C as if they had been made by those parties themselves. The statement by A is admissible against B because the statement is by law a statement that is attributable to B as much as it is to A. We therefore submit that the two confessions attributable to accused number 4 and other accused, much as they are attributable to accused number 2. Paragraph 22. In Hlongo's case, the Constitutional Court held that at 338B, paragraph 39, that, and we quote, at common law, there is an exception to the exclusion of extracurricular statements of accused if the statement constitutes an executive statement by an accused. It may be admissible against a co-accused if it were made in the furtherance of common purpose or conspiracy. There must be evidence aliunde to establish the existence of common purpose before the statements can be taken into account. My Lord, we've already referred to the confession of accused number 2, where he says, there the hostel, they were briefed and informed that the person to be eliminated was Mr. Senzo Meyiwa, and that Ms. Kelly Kumalo initiated this agreement, and that surveillance was then conducted, and there was a discussion as to how they were going to be positioned at the Kumalo's house. We therefore, my Lord, submit that in this matter at hand, the evidence of Zungu shows that there was planning at the Basotho hostel before the incident. This is further confirmed by what accused number 2 states in his confession, that the accused conspired to kill Senzo Meyiwa, as we've just mentioned. We therefore submit that the two confessions of accused number 2 can be classified as executive statements in the furtherance of a common purpose, and therefore an exception to the exclusion of out-of-court statement of an accused. Paragraph 24, we refer to the case of State versus Sheikh,
Yeah.
2007, Volume 1, SACR 247, decision of the SCA. In this case, the appellant had objected to the admission of the encrypted facts in question. The court held at page 235 G2H that, and we quote, the trial court has admitted the encrypted facts because it constituted an executive statement in the furtherance of a common purpose admissible against other soci criminis. As such, it admitted the hearsay evidence contained in the facts on the basis that of what is considered to be common law exception to the rule against hearsay. Paragraph 25, page 29, we refer to the work of Ditoy, again, commentary on the Criminal Procedure Act, page 24 to 27, point out that before such executive statements may be admitted, it must be shown that there was conspiracy and that the accused participated in it. Paragraph 26, we refer to the case of Kurashi, State versus Kurashi, is Qurashi and others, 2022, Volume 2, SACR 459, the decision of the SCA. The court held that the inadmissible evidence of a co-accused, or where the inadmissible admission of a co-accused leads to the discovery of real evidence, the pointing out by the co-accused led to the discovery of 4 bodies of the deceased in the murder trial. This evidence, said the Supreme Court of Appeal at page 38, stands on a different footing, and the distinction between real and testimonial evidence looms large. The evidence was held admissible. In essence, my lord, I think this refers to section 218 that the court quoted yesterday, and we submit, therefore, that in the matter at hand, what accused number 2 said led to the arrest of accused number 3, and a firearm was found that is ballistically linked to the scene. We therefore submit that the evidence here stands on a different footing. In paragraph 27, Ditoy at 2470 states that the fact that cautionary rule which would have been applied had the accused testified has been frustrated flow from the hearsay quality of the evidence. Caution could, in any event, be applied to the evidence of the statement itself. We are constrained to treat confessions and admissions equally, as we've just pointed out, but it may be better in respect of both to allow a measure of flexibility to deal with the exceptional case where the interests of justice would favor admissibility. If it is recognized that all objections raised by the courts to the reception of such evidence do indeed have as their source the hearsay nature of the evidence, it is difficult to imagine how Section 3(1)(c) of the Hearsay Act, if properly applied, could not conduce to the right results if that result captures the interests of justice as it is required not to do. So, my lord, the mainstay of our argument is that in the interest of justice, this hearsay evidence of accused number 2 should be admitted against accused number 4 and the rest of the accused in the interest of justice, as mentioned in section 3 of the Hearsay Act, paragraph 28. In S versus Robiana and others, 2009, volume 1 SACR, the very interesting judgment from the Siskai High Court, now the Eastern Cape. The appellants had cross-examined the accomplice on the contents of a statement he had made, which also implicated them, in order to show that he had contradicted what he had said earlier and that he should not be believed. The court held that a blanket ban against the reception of this evidence against the appellants would have led to an incongruity. To claim that the contents of the statement be ignored and not used to confirm the accomplice's credibility after a failed attempt to use evidence to destroy his credibility would be plainly absurd. The judge concluded that the statement should be received under Section 3(1)(c), and the writer Dito endorses this approach and mentions that this is a case where the interests of justice, if one were allowed to take them into account, would favor admissibility. If the blanket exclusionary rule would, however, make such an inquiry impossible, and might there not be other cases where the interests of justice might be frustrated by a blanket ban? And the writer then asks the following questions. What if, for instance, the co-accused were shown to be a person of the highest credibility? As we've just mentioned, my lord, that what accused number 2 states in his confession is corroborated by the witnesses who were in the house, the ballistic evidence inter alia, and we've submitted that it shows the highest degree of credibility of what accused number 2 states in his statement. And this is precisely what Dito is asking as to what, for instance, if the accused were shown to be a person of the highest credibility. His statement was made under oath in circumstances where the accused had ample opportunity to question him and challenge his evidence, where there existed strong indicia of the reliability of his statement, and where there was no cause to question the fairness of the trial if the evidence were adduced. In paragraph 29.
Sorry, who's the judge? Johnson?
In that case of, in the Robiana
Yeah.
case, we'll come back to
Okay,
it.
fine.
Yeah. My colleague will check that. In S versus I'm sorry, at paragraph 29, the Leonard Arthur Maddock Watney in 2014 SAR 855 at 870 states that, and we quote, it is submitted that a more flexible approach, so the author is also making the same argument as the writer Ditoe does, that a more flexible approach in the admissibility of evidence is required, and the discretion of courts in this regard should not be unnecessarily hampered. Greater relation of the rules about hearsay evidence entail and are alive to the inherent dangers involved in its admission. They should therefore be entrusted to decide the admissibility of all forms of hearsay, including mentioned here, including extracurricular admissions by co-accused, and if admitted, what weight to attach to the evidence. And at page 867, the writer states that the Ndlovu case did not hold that all hearsay evidence should be admitted. A decision not to admit hearsay evidence can therefore not be construed as deliberately deviating from the approach followed in the Ndlovu case. The writer then refers to the case of Libazi, 2010, Volume 2, SSCR 233 SCA, wherein the court, in not allowing the hearsay admission, the writer argues that the court, in not allowing the hearsay admission, cannot necessarily be construed as criticism of the approach in the Ndlovu case, and went on to argue that it was never the purpose of Section 31C to allow all hearsay evidence, but to grant a court the discretion to allow it. And in the Libazi case, the court, the SCA found cogent reasons not to follow the evidence of, not to allow the evidence of which the failure by the trial court to provide no reason at all must have played a major role. Paragraph 30. It is submitted that this is an appropriate case and in the interest of justice to invoke Section 31C of the Hearsay Act, as there are enough safeguards, as there is sufficient corroboration for the extra curious statements of accused number 2, as mentioned in the preceding paragraphs. The firearm found in accused 3's possession being ballistically linked to the bullet projectile found on the scene, and the fact that the downloads show that accused number 3 communicated with Ms. Kelly Kumalo. This morning, my Lord, we indicated that we the judges were in the Robiana case,
Yeah.
were Dlodlo, ADJP, Greenland, AJ, and Daoud AJ.
Who was described? Jojo.
Yes,
Okay.
I suppose he was the senior judge. Well, my Lord, we just briefly deal with Exhibit J and the evidence contained therein of Mr. Thabo Makaleni. I'm sorry, Thabang Makaleni. Thabang Makaleni.
Tabo or Tabang?
It's Thabang Makaleni.
Tabang.
Yes, Thabang Makaleni. We'll just neaten up this portion, my Lord. And we mentioned Roman figure 1. Mr. Thabang Makaleni made a statement on 27 October 2014, a day after the incident. The main thrust of the evidence is captured in Exhibit J, page 5, the first paragraph. The effects of his evidence is captured in Exhibit J, and this, my Lord, it's an exhibit that was handed up by the defense, and we'll argue that the defense, by handing up Exhibit J, which is the report by the then warrant officer Amanda Yvonne Steenkamp, consented to the hearsay evidence, And in Exhibit J on page 5, the effect of what is stated in this paragraph, my lord, is that says the fifth witness, Mr. T. Makaleni, residing at Mozamo 3942, compiled the faces of suspect B. He saw 3 unknown males in the vicinity of the gas station, busy on the cell phones. He saw them again at Kelly's mom's house. Suspect B stood at the gate. He gave the following description: African male, more or less 25 years, more or less 1.80 meter tall, slender build, medium brown complexion, clothing, black hooded top. Witness saw a golden insert in upper teeth, hairstyle, dreadlocks, facial hair, mustache and beard. Witness saw something in his hand that could have been a firearm. Witness could not describe the rest of the faces. We mentioned in Roman figure 2 that the defense themselves introduced this Exhibit J into the record. We submit, therefore, that they've consented to the hearsay evidence of Mr. Makaleni being admitted on the record as envisaged in Section 31A of the Hearsay Act, Law of Evidence Amendment Act 45 of 1988, which provides that subject to any other law, hearsay evidence shall not be admitted as evidence in criminal proceedings, A, unless each party against whom the evidence is to be adduced agrees to the admission thereof. In Roman figure 3, alternatively, we state that it is in the interest of justice to admit it, and we refer to the case of Kapa versus the state. It's a Constitutional Court decision, case number CCT 292/21, 2023, ZACC 1, 2023-4, Butterworth Constitutional Law Reports 370, and it is the decision of the Constitutional Court, handed down 24 January 2023. It concerns the admission of hearsay evidence in terms of the interest of justice tests as set out in Section 3(1)(c) of the Law of Evidence Amendment Act 45 of 1988. The Constitutional Court had occasion to consider whether the Western Cape High Court was correct under Section 3(1)(c) of the Law of Evidence Amendment Act to admit the statement of Ms. Bomikazi Dasi, who died before the trial. And we are submitting, my lord, that this case is on all fours with the issue pertaining to the admissibility of Mr. Makaleni's statement. In Roman figure 4, the High Court had ruled that the statement of this witness, who had since passed on, was admissible under Section 3(1)(c) of Act 45 of 1988. The Constitutional Court examined the provisions of Section 3(4) of the Hearsay Act, which defines hearsay evidence as evidence, whether oral or in writing, the probative value of which depends upon the credibility of any person other than the person giving such evidence. And the court held that Ms. Dasi's statement, as tendered by the state through the oral evidence of Sergeant Msolo, is hearsay evidence. And in that case, the state successfully applied for the admission of this hearsay evidence in terms of Section 3(1)(c) of the Hearsay Act. And this section, my lord, enumerates various jurisdictional factors that should be met before the evidence can be admitted. The court must consider the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, the probative value of the evidence, the reason why the evidence is not given by the person upon whose credibility the probative value of such evidence depends, any prejudice to a party which the admission of such evidence might entail, and any other factor which should, in the opinion of the court, be taken into account, and thereafter the court is of the opinion that such evidence should be admitted in the interest of justice. And in paragraph 8, the court dealt with the well-established principle that the trial court's decision must be based on the totality of the evidence available to the court. And in dealing with the interest of justice, held that no direct evidence can, however, be drawn between the crime scene at the applicant's house and his participation in the events that led to the death of the deceased. The High Court relied entirely on Ms. Darcy's statement to place the applicant on the scene and to establish his involvement in the fatal assault. Ms. Darcy's statement, therefore, plainly played a decisive role in the conviction of the applicant. And we submit, my lord, that the statement of Mr. Makaleni is crucial to place, and here I mean the evidence of Mr. Makaleni as contained in Exhibit J is crucial to place the assailants on the scene. I'm now, my lord, going to ask Dr. Sibanda to take the court through the evidence that has been tendered by the state, as indicated earlier on, and he will proceed from page 4 of our. Yes, it was handed up, my lord. We'll give the exhibit number as we go along, my lord. We'll come back to that exhibit number.
Okay, is Mr. Jonas going to interpret now, or when? After?
After the doctor is done.
Or after the, okay, fine.
Is it please the court?
Yeah, well.
I just want to raise a point in limine.
Oh,
Yes. I realize that the state is referring to an alleged statement of Mr. Makaleng that was introduced according to him, and it also referred to Exhibit J. I'm not so sure whether this is an opportune time for the defense to respond in this regard, because the state is exploring issues here. It says it is introducing that Exhibit J with a view to try and place the accused at the scene, or the suspect at the scene. State is not being specific, and we all know that this application is about accused number 4. So, as I'm saying, I'm not so sure whether this will be an opportune time, because as far as the defense is concerned, from the point on which I'm standing on, this is an entirely new aspect of the evidence altogether, which aspects it's been pushed through the back door subsequent to the comment that has been made by the court yesterday with regard to Mr. Makaleng. So I'm not so sure whether at the end of this application by the defense and the response by the state, would we also be afforded the opportunity to specifically deal with this crisp issue, not on the application per se, but this issue of a statement as it relates to Mr. Makaleng. The reason why I'm standing up, my lord, is simply because I don't want to be seated here and later on when we raise this point and it is then thrown back to us and said, but you seated there, you did nothing about it, my lord.
yes, Mr.
Thank you, my lord.
Please, by all means, I think the defense will be at liberty to respond to any issue that
Yeah.
any point that we argue.
As it is the court.
Is that okay, Mr. Mama?
I'm finding it difficult because
Hello?
I'm saying I'm finding it difficult because my colleague is raising the 7 requirements that are stipulated in his HSA Act, but he doesn't substantiate or support whatever application that he is making in terms of those requirements. Even at the time when he was afforded the opportunity to do so during the state case. So the 7 requirements must be met. There must be a formal application.
You can raise that in your argument, no problem. Okay. Yes, Mr. Doctor. Yeah, bro.
I'll proceed from
Page?
page 4, paragraph 5, summary of the text. States evidence, I will start with the people that were in the house during the commission of the offense. Paragraph 5.1. Zandile Khumalo, Mtokozi Zitwala, Tumile Madlala testified that on the evening of the 26th of October 2014, 2 intruders entered the house of the Khumalos, one wearing a hat, caramel jackets with dreadlocks, and with a firearm demanding money and cell phones. Longwe pushed the gunman and ran outside. A scuffle ensued between the people in the house and the intruders. The loud bang was heard and Kelly ran into the bedroom. The second intruder was tall, wearing a hoodie and an O-shaped beard, and followed Kelly to the bedroom she ran to. Senzo pinned the hoodie man against the wall and Tumelo punched him. Then the gunshot that made Tumelo go deaf went off. Tumelo went into the bedroom planning to exit through the window, but the bars prevented him. Zanile ran into the bathroom and Mtoko exited the house through the kitchen door. The witnesses found Senzo lying down with a bullet wound. The witnesses rushed Senzo to Busilong Clinic. Senzo was declared dead on arrival at around 21:15 on the 26th of October 2014. Paragraph 5.2, the neighbors of the Khumalos, 5.21, Kaya Ngasha testified that on the evening of the 26th of October 2014, he heard a noise signifying a fighting. Ntoko jumped to Ngasha's house asking for help, indicating that a problem had occurred, and jumped back to the Khumalos after not more than seconds. After informing his brother, they went outside and heard that some people had ran to the park, which was 100 meters from the Khumalos, not 200 meters. The park was searched, but nothing was found. This search likely took 10 to 12 minutes as it happened quickly. Kaya returned to the kitchen from the park with other neighbors and discovered Senzo lying on the ground facing upwards. They tried to help him stand up. Mtoko Tumele and others assisted in rushing Senzo to the hospital, and this was not a decision taken by one person. Everything happened so fast and he cannot remember who else. Kaya called the police because someone has requested him, and this likely occurred around after 20:00. Later, Kaya and his brother and other neighbors decided to follow Senzo to the hospital. Kaya, his brother and neighbors heard on arrival at the hospital that Senzo had died. Kaya and his brother and neighbors drove back home. 5.21, Tabiseng Mokiti testified that Tabiseng Mokiti, the younger sister of Megi Piri, had 3 shots around 20:00 on the evening of the 26th of October 2014 while chatting with her friend Yolanda Mota in her car, a Honda Ballade. The Honda Ballade was parked in front of the gates on the pavement. Tabiseng could see Zandi at the time because there was a small space for a gate next to an electric box. She's not sure if Zandi was standing on something or to be visible or what she was peeping through. After the first shot, the man passed running towards the park while still arguing whether it was a gunshot or not. Another shot went off. It was much closer than two males who passed running towards the park. A few seconds later, the third gunshot went off as Yolanda was opening the door. Of the two, one of them not big in terms of physique. He was neither lean as well. He was of an average height, and I remember that he had dreadlocks. And the very one with that big physique had hoodie on his head, with a head as well. He was taller than the other two that she has already referred to. Tabiseng had
Zandi crying for help, calling the ambulance. That was after the third sound. And then 5.3, Constable Matebula and Constable Mtetwa testify that on the 26th of October 2014, Constable Matebula and Constable Mtetwa were stationed at Fosloras Subs under the Vispol CSC. They were engaged in addressing complaints and conducting patrols. At 20:53, they arrived at the police station to facilitate an apprehension. While at the police station, they received a radio control notification regarding an ongoing shooting at number 13511 Kutbanong Street, Mzamo, Fosloras. Upon receiving this complaint, they seized all activities and swiftly proceeded to the scene of the shooting. They navigated directly to the indicated address and street as it's familiar to them. Following the directions provided, they moved towards the park. Upon arrival, they searched the area but found no individual present, thus prompting their return to the initial address. It appeared that the suspect had fled towards the park. They continued their search there, looking for any potential witnesses, but unfortunately, they encountered no one. Subsequently, they entered the residence along with Kumalo to conduct a further investigation. During this process, they requested that the premises be secured and then hastily proceeded to the hospital. Upon entering the hospital room, they discovered that Senzo was lying on a stretcher facing upwards. It was at this moment that they recognized that the area they had just vacated had now become a crime scene. Makumalo expressed her willingness to accompany them. Given their realization that an investigation was necessary at this location, upon their arrival, they utilized the tape to cordon off the scene. After a short duration, a photographer who introduced himself as Constable Musia arrived. Captain Zwani pointed out the various exhibits to him. Subsequently, upon returning to the police station, they completed the necessary docket and submitted it to the data capturer for processing. 5.4, the forensic field officers, Sergeant Musia and Lieutenant Colonel Mhlahlo. Sergeant Musia testified on 27th of October 2014 at about 002 a.m. He attended a scene at 1351 Kutwanong Street, Mzamo section, extension 11, Fosloras, where he met Brigadier Ndlovu, who pointed out certain points to him, of which he took photographs. He prepared a sketch plan. Key to photos are also attached to the station Fosloras 63610-2014. And then there's photos 1 to 2 taken of an easterly direction and indicate house number 13511 Kutwanong Street, Mzamo section, Fosloras extension 11, where an alleged shooting incident took place. Photo 3 indicates that the kitchen door where an alleged suspect gained entry. Point A, as per the sketch plan. Photo 4 indicates the kitchen door, point of entry as point A, and a bullet jacket was found on the scene of crime, which is point A1, and it is 1 times bullet hole behind the kitchen door, indicated point A2. A Scotch brown, grey, white head is found at the scene of the crime that allegedly belongs to one of the suspects. Point B, and X silver grey walking stick is found at the scene that allegedly belongs to one of the victims. It's point C as per the sketch plan. Point 5 indicates a close shot of the point of entry. Point A, a close up shot of a bullet jacket is found at point A1. On his second return, Sergeant Musia was joined by Warrant Officer Mhlahlo from the Provincial Crime Scene Management, and thereafter they conducted a walkthrough of the crime scene together with the crime management team. They started processing the crime scene. They began by first investigating touch DNA to avoid contamination. They followed with any other forensic exhibits. And lastly, they will investigate for fingerprints. They used the evidence collection kit. It is a sealed pack consisting of 2 swabs inside and 3 sheets, which accompanies one will accompany the exhibits to the forensic lab. The other one will be left in the docket, and the third one will be sent for investigation officer at the request of the photo albums. They managed to find the projectile on the kitchen top. They noticed that the bullet did not penetrate the door. They traced the search on the kitchen top, and this is where they found the bullet projectile. And On the morning of the 28th of October 2014 at about 8:30 in the morning, Sergeant Messiah booked all exhibits into SAP 459 with reference number 31110-2014. Paragraph 5.5, Colonel Stein testified that there was communication between Kelly Kumalo and her cell phone number 0827044358 with accused number 5, Nkani with cell phone number 0733059202 on the following dates: 2014-0803 and 2014-10-15, using the internet, which will not appear or show on a normal section 205. You can only get it by downloading if the phone is available. Colonel Stein testified that blackberry.net is an indication that Kelly Kumalo was using data. She was not using a normal cell phone call. Colonel Stein further testified that the phone number 0733059202 of accused number 5 was saved as NA on the phone book of Kelly Kumalo. Paragraph 5.6, ballistic evidence. Warrant Officer Rolofse testified on the 13th of February 2015 during the performance of his duties he received a sealed forensic bag with 3.11 times parabellum caliber CZ model 75 semi-automatic pistol with serial number obliterated and marked 34369/15 and 1 magazine. The witness confirmed that Exhibit 1, which is the firearm that was brought before this court, is the firearm that he examined. He also confirmed that this is the firearm because he could see that he engraved on the trigger guard with his own handwriting, and he also wrote on the box that was accompanying the firearm with his own handwriting. Lieutenant Colonel Mangena, the ballistic examiner, Colonel Serewo, Captain Chrobler, Captain Tini concluded that the bullet from the crime scene and TB03 to TB10 were fired from the same firearm that Warrant Officer Rolofse, after performing a microscope analysis. There were sufficient class and individual characteristics. DNA evidence 5.7, Captain Masetla, in terms of the swab and the head, Mapisa Mtokiziseni is excluded. 5.8, the evidence of Sizwe Zungu. He testified that 5.81, he is a police constable with 12 years of experience, stationed at Sebenza Subs. He knows Mnisi B, accused number 1, accused 1 is his neighbor back at home. Bongani, in brackets Mafika, Ntanzi is accused number 2, accused 3 is Mtobisi, Carlos Gadla, Nobe. He also knew him from back home. He saw him for most of the time here in Gauteng, but the first time he saw him for the first time in Fosleras. And then there is Mtokizisi Mapisa. He also remembers him from Fosleras, but not from back home. He is accused number 4. Then Tuseku Kenkani Ntuli, also think he saw him in Fosleras. He is accused number 5. On the 26th of October 2014, he received a call in the morning from Sifiso Zungu, also known as Gwabini, who is his son or his brother's son, to visit him in Fosleras Sutu Hostel. Paragraph 5.80, between 2 and 3, he will not be able to remember the exact time he arrived at the hostel. There were others as well from back home inside the hostel. Upon entering the hostel, there is an area that is sort of a kitchen. Makosonke told Constable Zungu that he had a bottle of Jameson. There were many people, but accused 1 was there, accused 2 was there, accused number 3 was there, accused 5 was there upon the arrival of Constable Zungu. 5.83, he couldn't remember all of them because he wasn't staying in the villages back at home. He was staying somewhere else. Gwabini will then remind him. If he remembers correctly, the person or people he reminded Constable Zungu were Gadla and Mafika, but the person he knew very well was Muzi. Accused 5 said that he was Nkani, but he knew him as being from a Zungu at the time, or as being a Zungu. Accused 2 is Mafika, accused 3 is Gadla, and accused 5 is Nkani. 5.84, whilst they were seated, accused 5 then requested a certain gentleman to ask Constable Zungu to give away because he was parked right behind him, so I could just reverse He did that and he went back inside. It was a grey polo hatchback. We were also singing and drinking and eating meat. Paragraph 5.8.5. The other incident that Zingo remembers was the time when Nkane had already left. They were seated there with the others and they had run out of liquor. They drove an Uno, which you think it was red. If he remembers correctly, it was accused number 3 and 4. And then the other one was the driver of the motor vehicle. They went to Tops. There was a certain shopping center there. The others, if he remembers well, bought liquor, then went back to the hostel. 5.86, we deal with now Exhibit S, which is the cell phone download, which Sergeant Mabasa testified on 3 occasions before this honorable court.